Welcome everyone. Thank you so much for being here. I just want to begin with a quick acknowledgement that McGill University is situated on the traditional territory of the Ghanaian Karaga, a place which has long served as a site of meeting and exchange among nations. And were it not for the pandemic, that is where we would be meeting today. So I would like to introduce our organization. We are the Runnymede Society, the McGill University's chapter of the Runnymede Society, which is a national student membership organization founded by the Canadian Constitutional Foundation. And we're dedicated to promoting and exploring constitutionalism, liberty, and the rule of law. Nommé en l'honneur de la prairie Runnymede où fut signée la Magna Carta par le roi d'Angleterre Jean sans Terre, la Société Runnymede organise des discussions dans notre université pour encourager la liberté d'expression et la diversité intellectuelle, qui sont des conditions nécessaires pour une société libre et démocratique. Les sujets les plus récents abordés durant nos conférences incluent les pouvoirs d'urgence durant la crise de la COVID, la loi 21, la règle Vavilov, le droit administratif en général et la théorie du double aspect en droit constitutionnel plus spécifiquement.
Thank you very much, Gabrielle, and I will introduce our guest speaker. So Professor Richard Ekins is a professor of law and constitutional government in the University of Oxford. He received his Bachelor of Arts, Bachelor of Laws with Honors, and Bachelor of Arts with Honors degrees from the University of Auckland, before going on to read for the Bachelor of Civil Laws, Master of Philosophy, and Doctor of Philosophy at Oxford. He works on questions in constitutional law and practice and in legal and political philosophy, with a particular focus on lawmaking, interpretation, and self-government. He has been a fellow at St. John's College, Oxford, since 2012. He leads Policy Exchange's Judicial Power Project and, with Nick Barber, the program for the Foundations of Law and Constitutional Government. He has published articles in a range of leading journals, and his research has been relied upon by courts, legislators, and officials in New Zealand and the United Kingdom. And without further ado, we will let Professor Ekins speak.
Oh, thank you, George, and thank you, Gabrielle. You can hear me, I hope? Very good. I can see nodding.
Yes, we do.
Excellent. Well, thank you both, and thank you to the Runnymede Society for having me along to speak today. I had the good fortune to meet some members of the Society in Oxford and in London in 2018, and I've been looking forward to continuing a conversation about constitutional affairs, which we began then. My topic, as you know from the title of the talk, is the relationship between the political constitution and the rule of law. I don't know to what extent the political constitution is a familiar term in Canadian scholarship, but I have it on good authority that it's, at one point at least, you had a constitution similar in principle to the United Kingdom, which makes the political constitution relevant to that extent. And I hope the UK's experience, especially in recent years, may prove instructive more generally. The political constitution and the rule of law are sometimes framed in opposition to one another. But my argument, on the contrary, will be that they are consistent, that a firm commitment to the political constitution is entirely compatible with robust support for the rule of law. And that properly understood, the two ideas are coherent and mutually supporting. In other words, they go well together. The political constitution is well placed to uphold and maintain the rule of law, and the rule of law helps protect the integrity of the political constitution. The flip side, I think, is that when judges and lawyers lose confidence in the political constitution, as many increasingly do, when they attempt to compensate for its perceived inadequacy, they're likely to damage the political constitution and the rule of law. The political constitution is constituted in part by legal rules, which impose limits on courts. Those limits are consistent with the rule of law. Indeed, I argue they help to realize the ideal. And even if they didn't, the rule of law would require that they were upheld until they were changed by lawful means. And when courts shrug off legal limits on their jurisdiction, they undermine the rule of law. So in insisting that limits are observed, one upholds the rule of law and protects the political constitution. And I'll try to illustrate some of these propositions by way of some recent UK cases. But I should begin by saying a little bit more about the political constitution. It's a term that aims to capture some of the main features of the Westminster Constitution. And in particular, it aims to stress the way in which some of the most important public powers and holders of public power are framed and disciplined not by law, but by political dynamics. Now, clearly some central features of our constitutional order are not settled by positive law. In many ways, the Westminster Constitution still has the form, the legal form that is, of a medieval monarchy, but the legal form is overlaid with the political reality of a parliamentary democracy. Constitutional conventions, competitive party politics frame how the UK is in fact governed. And the twin pillars of the UK Constitution are parliamentary sovereignty, and responsible government. The Queen and Parliament can enact any law, save that it may not bind its successors. Each successive Parliament then is legally free to make or change the law as it sees fit. Parliament's responsible for legislating for the common good, and parliamentarians are well placed by disposition and institutional design to exercise that power responsibly. Now, there is, of course, very often reasonable disagreement about how best to legislate. The question of what legislation should be enacted, of how best we should be governed, it's political. Parliamentary sovereignty is a legal rule which makes the politics matter. Electoral success confers real legislative power, power then disciplined by ongoing political competition. The Constitution places considerable trust in Parliament to exercise its freedom responsibly. But the political constitution doesn't assume legislators will always act reasonably. Later parliaments will often have to repair the failures or mistakes of earlier parliaments, and each parliament knows its successors will be free to undo its legislative changes. Indeed, within parliament, the minority will appeal to the electorate for support, precisely in order to enjoy the capacity later to exercise legislative authority, in part to be able to undo particular laws. So parliamentary sovereignty makes radical legal change, and thus radical social change, possible. But it also introduces a kind of self-tempering dynamic, for no parliament remains forever. Lasting change requires consensus, in which later parliaments choose to leave well enough alone. In enacting statutes, the Queen and Parliament is a single institution, which acts as one. But in understanding its constitutional position, its internal composition is vital. The House of Commons has the whip hand, Her Majesty's assent is more or less assured, the Lords recognise the primacy of the Commons, at least in financial matters in relation to manifesto commitments. And that's a primacy secured first by principle and convention, secondarily by law. Within the House of Commons, government and opposition constantly compete. The opposition can expect to routinely lose votes in the Commons, although in some cases it may succeed in opening up fractures in the government support coalition. But it appeals to the electorate, and parliamentary deliberation and action will form part of a wider public conversation in which parliamentarians sometimes lead and sometimes follow. The principle of responsible government provides that government is carried out in the Queen's name by ministers drawn from and accountable to Parliament. The Queen's obliged by constitutional convention to appoint as Prime Minister the person best placed to form a government that can command the confidence of the Commons. In that way, the outcome of an election, the balance of parliamentary opinion, settles who governs. If the House of Commons withdraws confidence in the government should either resign, making way for a new government, or Parliament should be dissolved and an election held, returning a new House of Commons, changing the balance of political power. That confidence principle, as one might term it, is a fundamental feature of the political constitution. Now, it's the government rather than Parliament that's responsible for governing. But Parliament will hold the government to account for its policy, for its exercise of statutory and prerogative powers, for its legislative proposals, for its failures of leadership and action. The government often has power to act without express parliamentary support, but it must answer for its actions, and anticipation of criticism or challenge is important. Some policies will require enactment of new legislation, and nearly all require financial support. So no government can govern for long, let alone govern well, without ongoing parliamentary support. The government may expect its legislative proposals will be accepted by the House of Commons and eventually by the House of Lords, but it may need to make concessions to secure support, and it will likely only move proposals when it anticipates that support will be forthcoming. So the restraints on the Queen and Parliament are political, both in the sense that Parliament's internal structure divides power and frames political contest, but also in that engagement with, anticipation of, wider public reaction, made relevant by party competition, that's a key discipline. And in addition, Parliament's itself subject to constitutional conventions, which shape its deliberation. The main restraints on the government are political, both in the sense that the government depends on maintaining the continuing support of the Commons to be able to rule effectively, and in the end to rule at all, but also in the sense the government forms part of Parliament, subject to the same wider political dynamics, public opinion, electoral competition serving as a powerful limit. Now, to my mind, this is a good way to govern and to be governed. For many years, it's made self-government and good government, reasonably good government, possible in Britain, as well as in similar countries elsewhere. The political constitution can't be understood wholly apart from the law, because it's constituted in part by legal rules that confer power subject to political rather than judicial control, as well as by legal rules that make political support indispensable if one is to rule. Parliamentary sovereignty is a legal rule about legislative competence, a rule that makes the balance of power or opinion in the Houses of Parliament of the utmost political importance. The government's dependence on Parliament is a matter of constitutional convention, but it's reinforced by the practical difficulty of governing without parliamentary support, precisely because the government has no legal power to levy taxes or to change the law without Parliament. More generally, ministers are subject to the ordinary law, and they require legal power, whether prerogative or more often statutory, in order to act in ways that otherwise are forbidden by law. The law of the Constitution supports the political constitution by disabling judges from quashing acts of Parliament and by making the intention of the enacting Parliament settle an act's meaning. The merits of an act of Parliament are thus settled in Parliament and not in the courtroom. The meaning and effect of an act of Parliament is settled by Parliament's will, not by judicial fiat. The law of parliamentary privilege protects the proceedings of Parliament from challenge in court, and in this way the law maintains Parliament's legal freedom to act as it sees fit. Whether Parliament acts well is to be determined politically, not by application of legal rules. Relatedly, the law prohibits judicial review of decisions about government formation. The Queen's duty to appoint or dismiss ministers, the government's duty to resign if confidence is withdrawn, these are matters of constitutional convention, which the law removes from courts. In other words, the law itself recognises a sharp distinction between legal rules and constitutional convention, and provides that courts only have jurisdiction in relation to the former. So the role of the court is to uphold the law of the land, not to guard the constitution at large. The law of judicial review polices legal limits on how ministers and other public bodies act, limits justified, in part at least, by reference to Parliament's authoritative lawmaking choices. And importantly, the law of judicial review issues, sometimes with mixed success, review on the merits, which remain for the minister to decide, for which he or she has to answer to Parliament. And in relation to some important prerogative powers, the law prohibits judicial review altogether, at least in relation to the exercise as opposed to scope or existence of the power. Whether to conclude a treaty or to wage war, for example, is for the government, not the court, to decide, with government having to answer to Parliament and the people. Now, these are legal rules. They make clear who has authority to decide and that it's not the court. Their rationale, in relevant part, is that they reserve to responsible, representative institutions questions that they alone should decide, free from judicial interference or supervision. The law of the Westminster Constitution has long set its face against judicialisation of high politics. Relationships between the Queen, Parliament, government, the electorate are political. The law recognises the Crown's powers and the Queen and Parliament's authority, but leaves to the office holders, in conversation with the people, responsibility for their proper exercise. Now, Parliament's lawmaking authority can, of course, be used to change the law of the Constitution. And some of the legal rules that help frame the political constitution have been adopted in this way, including the Bill of Rights, 1689, and the Parliament Acts, 1911 and 1949. But Parliament's authority can also be used in ways that compromise the political constitution, as it seems to me was the case in enacting the European Communities Act 1972 and the Human Rights Act 1998. The Fixed Term Parliaments Act 2011 is a more recent cautionary tale. The Act removed the Queen's prerogative power to dissolve Parliament, changing the law in relation to the timing of elections. It was almost disastrous in 2019, and it looks set to be repealed reasonably soon. To my mind, the political constitution takes law seriously and keeps it in its proper place. The government's subject to the law of the land, but it's free to invite Parliament to change the law. Parliament's not subject to law, save that it has no authority to bind its successors. But that freedom's justified because legislative freedom is not a fit power to be restrained by legal rules, unless the rules are specific and subject to further legal change if necessary. Empowering judges to question the merits of legislation would simply relocate politics to the courtroom. In ruling out legal challenges to acts of Parliament, the Constitution protects the rule of law. Officials and citizens alike can rely on the statute, secure in the knowledge that it cannot be quashed. And courts are prevented from deciding, in the course of adjudication, what the law should be. If statutes are a source of law especially well suited to the rule of law, as I think they are, then the primacy of statute, which parliamentary sovereignty realises, helps secure the rule of law. In preventing courts from adjudicating disputes about parliamentary proceedings, about constitutional convention, about the relationship between government and parliament, or about the exercise of certain prerogative powers, the law that secures the political constitution also helps secure the rule of law. The rule of law requires certain types of action to be governed by general rules, but not all. The subjection of some power to judicial control is not necessarily an advance for the rule of law. It's only an advance if the court's able to limit the arbitrary use of power without frustrating its effective use, by applying general rules that are fit to govern the power in question. In relation to some questions about how we're governed, there are no legal standards to apply, either because no lawmaker has created them, or because the questions are unfit for such regulation. And in preventing courts hearing such questions, the political constitution vindicates the rule of law. The political constitution aims to avoid a futile attempt to substitute law for politics. If disputes are settled not by application of positive law, but by the court's free choice about what should be done, one cannot rely on the law. Litigation becomes politics by other means. Much better to keep legal reasoning as technical reasoning, to enable judges to keep faith with settled law without having to remake law in the course of adjudication, or to answer questions about how we should be governed for which they have neither competence nor legitimacy. The rule of law is indispensable to the political constitution because it's an ideal about how our law, the positive law of the land, should stand in relation to our government and public life. The political constitution has no quarrel with courts upholding the law in adjudicating disputes. On the contrary, the political constitutionalists should insist on exactly that. But the rule of law also requires the limits on courts to be upheld, limits that settle authoritatively who is entitled to answer certain questions, which in some cases will not be the court. And even if those limits are wrongly framed, the rule of law disciplines how they should be changed. Specifically, it's not open to judges in the course of adjudication simply to abandon them. Well, the legal rules that frame the political constitution seem to me to have come under some pressure in recent times, in large part because many lawyers and judges take the political constitution to have failed. For some, the promise of the political constitution has proven illusory, because parliamentary accountability is non-existent, constitutional conventions do not restrain, and competitive party politics and electoral accountability are inadequate disciplines on public power. For others, the political constitution simply amounts to an absence of the rule of law. For both, I think, the remedy is the extension of judicial control, whether to restore the faded promise of the political constitution or to compensate for its imagined failure. The argument that the constitution has failed seems to take for granted that the executive simply dominates parliament, with a tame parliamentary majority permitting the government to do as it pleases. I think this is bad political science, confuses the government's leadership within parliament for dominance over it, ignores the extent to which parliamentary opinion frames the government's actions. But loss of confidence in the political constitution is not simply a consequence of an inadequate, in my view, appreciation of the dynamics of parliamentary government. It also arises from a wider skepticism about majority voting and about the electorate itself. For some lawyers and judges, as for other elites, the people are the problem and their participation in government needs to be strictly limited to avoid disaster. Now, from this point of view, there's an obvious appeal to an ever more expansive idea of the rule of law, which confers on courts ever more responsibility for deciding contested political questions. It's an idea that resonates with the rise of dynamic treaty commitments in which new creative decisions made by European courts effectively limit the UK's freedom of action. Now, it's against that background, I think, that Brexit was received with such horror by so many lawyers. The point wasn't just status quo bias, I think, but a fear that once the EU treaties fell away, Parliament, dominated by a rapacious government or the agent of a rabid electorate, would be free to act. That is, the assumption was that the political constitution had failed. One could not rely on the dynamics of parliamentary government or on electoral accountability. Now, I'll come shortly to some of the cases that arose during the long Brexit crisis. But I want to first note briefly a series of cases that predate Brexit or are unconnected to it. The cases involve the apparent determination on the part of some judges to subject Parliament itself to the rule of law, either by openly quashing certain statutes it might enact, or by misinterpreting its enactments in order to protect rights or other constitutional fundamentals as the judges see them. Some judges have publicly cast doubt on parliamentary sovereignty's continuing legal force. In the famous Jackson case, which involved a challenge to the fox hunting ban enacted using the Parliament Acts, two judges flatly asserted that the rule of law was becoming the true fundamental of the Constitution, and that the scope of Parliament's lawmaking authority was thus open to question. They objected to parliamentary sovereignty in part because they took Parliament to be dominated by the House of Commons, which was in turn dominated by government. Much more recently, in the judgment of 2019, 3 Supreme Court judges, 3 of 7, asserted that the rule of law means it's for judges, not Parliament, to determine the limits of judicial review. That is, they indicated that in a later case, they might simply refuse to obey a statute that imposed clear limits. Now, the dicta in these two cases seemed to me to manifest a profound loss of confidence in the political constitution. If judges were openly to reject parliamentary sovereignty, they would be overthrowing the fundamental legal rule of the Constitution and asserting a novel judicial power to quash statutes. Now, quite apart from the means by which it would have been introduced, this newly asserted jurisdiction would not be an advance for the rule of law. The legal validity of statutes would be put in question, with no clear grounds on which courts would quash them, a quashing that would take place with retrospective effect. Inevitably, judges would be invited simply to quash statutes that seemed to them to be unjust. There would be no legal standards on which they would act, even if they were to purport to be limited by the idea of the rule of law, an idea that can be a capacious idea in certain hands. Now, I doubt British judges will attempt to quash a statute anytime soon. The dicta in the 2005 Jackson case were publicly repudiated by Lord Bingham, the leading judge of his generation. Changes on the Supreme Court recently, or in the last 2 years, I suppose, make the 2019 dicta less likely to advance. More interesting than outright defiance of Parliament is the trend towards misinterpretation of its enactments, with courts calling in aid the principle of legality. That principle has a kernel of good sense. Courts should be slow to conclude that in enacting some statute, Parliament intends to change the Constitution or to qualify settled legal rights. But the principle is open to abuse if courts use it as a license to ignore clear legislative intent. And in a number of important Supreme Court cases, it seems to me to have been abused in that way. But I want to turn now to 2 Supreme Court judgments that bookended the Brexit saga. And the cases don't involve courts attempting to impose the rule of law as they see it on Parliament. It involves rather an attempt to protect Parliament from the government and thus to guard the Constitution. I argue the attempts fail and the court does damage to the rule of law and the political constitution. Now, one immediate consequence of the 2016 referendum, the outcome of the referendum that is, the Brexit referendum, was to encourage opponents of the UK's departure from the EU to attempt to mobilise Parliament against Brexit. The government had made clear its intention to honour the vote, and thus the best hope for thwarting Brexit was to persuade Parliament to ignore the vote or to require a second referendum. After June 2016, it became a commonplace in certain quarters to deplore the government's dominance of Parliament, to lament the rise of populism, the decline of parliamentary democracy, and to make quite wild comparisons with Henry VIII, Charles I, and the collapse of Weimar Germany. As that may suggest, it was a fairly febrile time in public discourse, perhaps especially so in legal elite circles. The first Miller case began in autumn 2016 and was decided in the end by the Supreme Court in January 2017. And the question for the court was whether the government was free to trigger Article 50 by way of the prerogative. exercising the UK's treaty right to begin the process of terminating the EU treaties in their application to the UK, or whether new legislation had to be enacted to that end. Now, that was a legal question, a question that turned in part on the terms of the European Communities Act in 1972. And the majority ruled that new legislation was required before Article 50 could be triggered. Now, I think there's much to criticise in the judgment, as the dissenting judgments make clear. But the point I want to note now is the majority's holding that leaving the EU was such an important decision, such a constitutionally important decision, that it could only be made by way of Act of Parliament. The UK constitutional law has never required, quote, important decisions, end quote, to be made in this way. It might well have been good constitutional practice for the government to have invited the Houses of Parliament to support its policy on triggering Article 50, to support it by way of resolutions or by agreeing to legislation. And in the end, on the third day of the Supreme Court hearing, the House of Commons agreed a motion to this effect, supporting the government in triggering Article 50 by the end of March 2017. However, it was not for the Supreme Court to manage the relationship between Parliament and government, to impose its own prescription for good constitutional practice. The court acted wrongly in exercising its jurisdiction in this way, giving a major tactical victory to political opponents of Brexit and encouraging further political litigation. In any case, Parliament did not need protecting from the government. It was more than capable of deciding whether to support or oppose, question or challenge the government's policy. So I think the whole premise of the judicial intervention was unsound. Now, I said it was a tactical victory. Its strategic significance for political opponents of Brexit was much more muted, because the government simply moved a short bill, a very short bill, authorising the Prime Minister to trigger Article 50, which Parliament duly enacted. House of Lords toyed with delaying, but they folded pretty quickly. But I think a false narrative was established around this time, especially in elite legal circles, that Parliament's rights had been vindicated by the Supreme Court, that the government had otherwise been riding roughshod over parliamentary democracy, that litigation saved the day. And that narrative contributed materially to the constitutional crisis of autumn 2019. In particular, it encouraged the Supreme Court, in the second Miller case, to act wrongly. Late August 2019, the Prime Minister advised the Queen to prorogue Parliament for 5 weeks, from the second week of September until mid-October. Prorogation was highly controversial, unsurprisingly, but when the House of Commons returned in very early September, before prorogation, no move was made to withdraw confidence in the government. Likewise, no legislation was proposed, let alone enacted, to require Parliament to stay in session. Legislation had already been enacted back in July that year, making provision about prorogation in the autumn. But the proposed prorogation was entirely consistent with that legislation. Instead, Parliament enacted legislation that was intended to block a so-called no-deal exit, which would require the government to apply to extend Article 50 if no deal had been ratified by 31st of October. Parliament was then prorogued and an unusually long session of Parliament brought to an end. Not quite 2 weeks later, the Supreme Court ruled that the prorogation had been unlawful and that Parliament was not, after all, prorogued. It's a remarkable judgment, and I think it makes vivid the extent to which judges are increasingly willing to abandon settled law in order to compensate for imagined deficiencies in the political constitution. The law of the Constitution clearly provided that the prerogative power to prorogue Parliament was not subject to judicial control, save to the extent that statute otherwise provided. What the Supreme Court did was to assert a new, freshly minted legal limit on prorogation, a limit which can be summed up in the proposition that prorogation is unlawful unless a court, and in due course the Supreme Court itself, is satisfied that there are good reasons for the prorogation. I think that turns the Constitution on its head, in relevant part. It's for the government, accountable to Parliament and the electorate, to decide whether some controversial prorogation can be justified. It's for the Queen and extremists to conclude she should refuse advice to prorogue Parliament, perhaps, for example, if the government had clearly lost the confidence of the House of Commons. It's never been for courts to judge these matters, and long-settled law made that quite clear. The Supreme Court purported simply to be policing the scope of the power to prorogue Parliament, rather than controlling its exercise. But the judgment collapses the two, I think, asserting an entirely novel scope, which, as I say, amounts to the proposition that the court must be satisfied that there is good reason. The judgment's a lawmaking act, a rushed, ill-judged lawmaking act. And the law that the court has made politicizes adjudication. It invites courts to evaluate questions of high policy and partisan politics, and it makes further future political litigation inevitable. Now, the court rationalized its intervention on the grounds that this prorogation, and in principle any prorogation, cut across the fundamental constitutional principles of parliamentary sovereignty and parliamentary accountability, which the court had to protect. But parliamentary sovereignty had never meant that Parliament must remain in session. The court asserted a novel understanding of the principle in order to rationalise expanding its power. Likewise, parliamentary accountability is a ground to limit judicial review, insofar as the proper controls on some public powers, as the law itself recognises, are political rather than legal. Here, the court turns parliamentary accountability against the political constitution, rationalising its intervention into politics on the grounds that it's maximising political accountability. In fact, the court's simply taking sides in a political controversy and distorting the otherwise clear law that framed how that controversy should play out. The court also flatly rejected, as inadequate, practical limits on the power to prorogue. The limits included the fact that no government can govern effectively or in due course lawfully without ongoing parliamentary support, including support for financial legislation. The Supreme Court dismissed the practical and political limits on the power to prorogue in order to justify its invention of justiciable legal limits, limits that went well beyond what Parliament had enacted, including what it enacted only a month before the prorogation in question. Now, I think the court thought it was protecting Parliament, but in fact, it was rejecting the political constitution in relevant part. And the law, it was also rejecting the law, which was intended to protect that constitution from political litigation and judicial interference. In that way, the court compromised the political constitution and the rule of law. Now, finally, I should add that, to my mind, the court's assertion of judicial control over prorogation was also forbidden by Article 9 of the Bill of Rights, 1689, which protects parliamentary proceedings from being questioned in court, a provision of our law that's of fundamental constitutional importance, as judges often otherwise recognise. So in short, the Supreme Court asserted new judicial controls over prorogation in order to protect what it thought was a helpless Parliament and to compensate for the weaknesses it thought it saw in the political constitution. But Parliament needed no protection. The political constitution was more robust than the court thought. The court's intervention departed from settled constitutional law, including the Bill of Rights itself, law that was intended to protect the political constitution from judicial interference. Now, this is scarcely an advance for the rule of law, not least since the law that the court's inventing in the course of adjudication, no less, that law makes legal validity turn on the court's political evaluation, which is not a fit ground, on which to determine lawfulness, let alone a stable or certain ground. And the court's intervention weakens the political constitution, undermining the relationships that should obtain between government, parliament, and electorate. In 2019, helped make a bad political crisis into a worse constitutional one. Excuse me. The unfortunate fact, it seems to me, is that government has increasingly good reason to fear that political opposition will be played out not only in Parliament and the country, but sometimes also in the courts. And both Parliament and government have good reason to fear that in some cases, the courts will not faithfully give effect to acts of Parliament, but will distort or undermine them. Now, the judges in question may think they're carrying out a slow project of building up the rule of law. In fact, I think they're slowly chipping away at the political foundations of the rule of law, encouraging political litigation that casts aside disciplined legal technique and makes courts simply into another site of political power. They're also doing significant damage to the political constitution and the constitution's capacity to enable political competition, effective government, and political accountability. The opening paragraph in the Supreme Court's second Miller judgment, Cherry Miller, as it's often known, that judgment asserts that it's a one-off. Now, experience and logic teaches otherwise, and the court cannot control how its judgment is received. Claimants will, of course, rely on the judgment as a staging post for new judicial interventions. Weaponizing constitutional principle against settled constitutional law will not end here. Likewise, the court's conflation of scope and exercise, its subversion of the Bill of Rights, 1689, those are techniques that later lawyers and judges may find hard or difficult to resist. The risks of future political litigation, I think, are made clear when one considers the reaction by some lawyers to the proposed repeal of the Fixed Term Parliaments Act. The government's bill, which is before the Houses now, would restore the prerogative power to dissolve Parliament. In light of the Supreme Court's prorogation judgment, the bill, to my mind, wisely includes a clause intended to prevent judicial review of dissolution. Without such a clause, Cherry-Miller-style litigation would seem to be very likely. It might well culminate in judicial control over the timing of elections. Now, that outcome would make a nonsense of Parliament repealing the Fixed Term Parliaments Act. It would also be extraordinarily damaging to the rule of law and parliamentary democracy. Parliament should oust the jurisdiction of the courts in relation to dissolution, which would protect courts from themselves, shoring up the political constitution and the rule of law alike. Legislation to this effect would also simply protect the long-established legal understanding, ruling out the kind of innovation, to put it politely, that one saw in the Cherry-Miller judgment. And it has to be open to Parliament to affirm the law as it has long stood and to rule out its change. Yet the reaction of some lawyers and academic lawyers to the proposed bill has been revealing, with various submissions to Parliament insisting that judicial intervention must remain a possibility and that courts would and should not give effect to the ouster clause. Now, for my part, I take the bill repealing the Fixed Term Parliaments Act to be a welcome first step in the renewed exercise by government and Parliament of their constitutional responsibilities. The willingness of some judges in some cases to jettison the rule of law and the political constitution warrants an answer, which is to say legislation should be enacted that restores the law otherwise impugned and thereby encourages a return to judicial discipline. Now, I've been arguing for some years that judges should take seriously the limits that the law imposes upon them, limits which help secure the rule of law and preserve the political constitution. And you might be interested in the reaction this argument sometimes elicits. In some cases, the commentary, my commentary, is simply attacked as partisan politics. But I say that the case against political litigation is a powerful one, regardless of who is in power. In attempting to vindicate the political constitution and the rule of law, I think I'm taking my place in a long-standing cross-party tradition of British law and government. Now, in other cases, the attack on my work and those who take similar arguments has been rather more fundamental. Now, I noted earlier that Weimar Germany comparisons are all the rage these days. In 4 articles published last year, Professor David Deisenhouse, University of Toronto, well known to you, I'm sure, has asserted that I'm guilty of a Schmittian logic, misusing legal techniques to strip away constitutional checks and balances and thus make space for authoritarian politics. In other words, he argues, pretty directly, same cloth as Carl Schmitt, the notorious proto-Nazi jurist. Now, that's a pretty serious charge. I think it's also false, and Deisenhouse, to my mind, cannot mount a remotely plausible case in its support. Schmitt's aim, as Deisenhouse reports it, and he knows a lot more about Schmitt than I do, Schmitt's aim was to undermine the Weimar Constitution, free the executive from restraint, in order that we'd be better placed to implement the will of the people and forcefully distinguish friend from enemy. My aim is to defend and restore the UK's traditional constitution, which makes provision for an effective executive, yes, but one radically dependent on Parliament and the electorate. The executive is also entirely subject to the law of the land unless and until Parliament changes it. In the Constitution as I see it, Parliament is not subject to law, but it is subject to politics, and government subject to both, save that in relation to some public powers, including prorogation and dissolution, the law makes the main controls political and practical. The political constitution takes the law seriously, helps political opponents share in self-government by way of parliamentary democracy. In other words, delivers friends rather than his enemies. And in undermining the law of the constitution, one puts all that at risk. So I've challenged judgments that seem to me impossible to square with the law of the constitution, including especially parliamentary sovereignty, and which thus threaten parliamentary democracy. It's not a novel line of argument, I'm afraid. It's certainly open to question and challenge, but it's also clearly not some kind of apology for authoritarianism. Well, let me conclude by saying again that, to my mind, properly understood, the rule of law and the political constitution go hand in hand, with law and politics jointly constituting government. The political constitution makes provision for authoritative lawmaking and thus for disciplined adjudication, in which political questions are reserved to the political process. The integrity of the political constitution is assured in part by way of the set of legal rules that prohibit political litigation interfering in the dynamics of parliamentary government. Some judges have wrongly lost confidence in our governing arrangements and adopted an exaggerated and unsound understanding of the rule of law. The likely consequence, I think, is political litigation, constitutional instability, and a loss of respect for law. Judges who reason in this way, I think, are likely to distort the political constitution and compromise the rule of law. Judges and lawyers should instead recognise the moral appeal of the political constitution, follow the settled positive law that maintains it, and thereby help uphold the rule of law. Well, that's what I want to say to you, and I look forward to your questions, comments, and challenges. Thank you.
Well, thank you very much, Professor, for your talk. So now there's a Q&A period. So the floor is open for questions. So you can either send the questions in the Q&A. So we already have a question. I will read it. Or you can also, if you wanna ask your question viva voce, you can raise your hand, and I will allow you to speak if you want to ask your question. So first question is, so what do you believe are the influences on this intersection between the rule of law and political constitution? Particularly, do you think there are any natural law or positivist thoughts that are fundamentally replicated in the application of the rule of law through constitution? So that's the first
question. So what's the connection to sort of wider currents of legal philosophy? Well, I think of myself, for what it's worth, as a legal philosopher working in the classical natural law tradition. And I think the classical natural law tradition takes positive law pretty seriously. If you want a good account of the value of positive law, you go and read chapter 10 of Natural Law and Natural Rights by John Finnis, and similar work. Of course, many legal positivists take law extremely seriously too. There's a different philosophy, perhaps, thinking of jurisprudential currents, to that of Ronald Dworkin, who I think does view legal reasoning as much more an ongoing moral argument, political contest, and so has less space and less respect for legal reasoning as technical reasoning. So the idea that you have that legal reasoning can do without controversial moral judgments, or legal reasoning should do without it, is anathema to him, and I think his views have been highly influential. I mean, he's a very clever man, of course, but his influence on legal reasoning, I think, is unfortunate.
Okay, so we have a second question in the Q&A, so I'll read it again. So Professor Ekins mentioned that British courts can't invalidate statutes. My understanding is that UK judges have used their interpretative mandate in the Human Rights Act to essentially rewrite Parliament statutes via interpretation. What is your view of these strained interpretations? Is this problematic from the perspective of the political constitution and or the rule of law? Thank you for your engaging talk.
That's very kind. Yes and no, I suppose, is the answer. So it's true that courts in some cases have used Section 3 to read statutes in surprising ways. To some extent, they're required by Section 3 to read statutes in ways they otherwise wouldn't read them. And I'm no fan of the Human Rights Act, but the Human Rights Act is an act of Parliament, and every judge in the land has to give it full and faithful effect until such time as it's amended or repealed. And I've criticised judges for, as I see it, failing to give full effect to the Human Rights Act. Quite how one understands Section 3 is to some extent an open question. I mean, it's a lot of case law now, but I've been critical of some of the ways the courts have understood it. And in some cases, I think their reading of the statute they're interpreting has been unjustified and unjustifiable, not justified by Section 3, and has distorted what Parliament had decided and makes Section 3 a problem. There are more respectable and restrained understandings of Section 3 as well. But again, this is an exercise by Parliament of its authority to change the law of the Constitution. It's then modified in turn by the way the judges receive it, which is open to criticism. But Parliament has to take responsibility for its enactment of the Human Rights Act. And so much of the concern about the impact of the Human Rights Act should properly be directed at Parliament.
We have quite a few questions coming in through the chat here, so I can read the third one by an anonymous attendee. Would you say your argument is restricted in countries like the UK of unwritten constitutions? Does it change when there is a Bill of Rights?
Well, I skipped over pretty quickly the Human Rights Act, as you know. I mentioned it and someone rightly asked about it. And rights adjudication in general, I think, is modern rights adjudication is often a problem from my perspective in terms of its impact on the political constitution and the rule of law. I think it sets in motion dynamics that are highly problematic. If you have one as part of your positive law, then of course you've got to deal with it. And there's a question as to whether one should have one. The famous article on the political constitution back in 1979 in the Modern Law Review was partly animated by a concern that Britain not adopt a sort of a proper Bill of Rights or a Bill of Rights. I think the argument still runs, though, and part of the reason I talked about cases, the cases I did, other than thinking they were quite interesting and important and illustrative, was that they don't involve human rights. They don't involve rights adjudication. And you see some very important tensions and willingness on the part of courts to some extent to go beyond, even when it's not a question of rights compatibility or so on in place. If you have a constitution that imposes hard-edged legal limits on the legislature, then some of my analysis changes to some extent, I think, and those are legal limits you have to deal with, but it will probably make space nonetheless, or could do, for political dynamics within the frame set by those legal limits. Part of the problem, I think, sometimes with bills of rights is that they can be totalizing documents. The idea of total constitution, namely that the rights will always have some implications, so there'll always be a justiciable question. And that seems to me problematic insofar as it squeezes out political responsibility and choice. Now, that said, it may be that courts nonetheless stay their hand to some extent to make sure there is some residual remaining political responsibility, recognizing that they're not best placed to make all these decisions. But that's unstable, I think.
The next question is by Stephen Armstrong. And they ask, is your view of the political constitution confined to the British parliamentary tradition? In Canada, our MPs sadly almost never vote against their party, with the result that in our system, the executive dominates parliament rather than the other way around. Does a circumstance such as that change your analysis of the role of courts vis-a-vis parliament?
Well, I thought to some extent Canada did share in the British parliamentary tradition, but maybe the degree of sharing is an open question. And the jurisdictions I know best, New Zealand, where I'm from, and the United Kingdom, the argument perhaps is at its most forceful. But even in those jurisdictions, you get that point is often made. And I understand Canada has extremely tight, strict whipping arrangements that perhaps are stricter than elsewhere. Certainly, British parliamentarians seem increasingly rebellious, and one of the poisonous fruit of getting a large parliamentary majority is that it inclines many of your colleagues in Parliament to vote against the government more readily. So I don't. Perhaps it does change it, but I think, in a sense, that would suggest there's something wrong with the politics insofar as the parliamentary dynamics are overly rigid and need some adjustment. I haven't studied Canadian parliamentary dynamics, so take that for what it's worth. But I'm always a little bit skeptical when I hear assertions made about the nature of the relationship, partly because I read these assertions made about the British situation, and I think they're often misleading. They often fail to see the restraints, the restrictions, the anticipation, the difference it makes. Even if you've got a tight whipping arrangement, you still can't take your votes for granted, not because people are going to throw away the whip on the floor of the House, but because you'll destroy your parliamentary cohesion, and you'll undermine your party in other ways. Governments often make rash decisions, clearly, but they're also to some extent savvy, I think, and take into account the risks that are open to them and the challenges they're likely to encounter.
So we're going to keep you busy for a bit. We've got some more questions. The next one is by Carrie Sun. How should one respond to the increasing tendency in contemporary discourse to redefine concepts like the rule of law to encompass tendentious political positions or policy agendas?
Obviously, I'm in much sympathy with the question. I think the answer is to articulate a more attractive and more disciplined account. So I mentioned the article in the Modern Law Review by John Griffith, The Political Constitution. And it's a good article, well worth reading, as is some of his other work. But there was a little bit of a tendency, I reread it in preparation for speaking to you, a little bit of a tendency to for him to be cynical about the rule of law, as though it's sort of a boo word people invoke to get what they want. And sometimes that's sort of true, but it's a pretty valuable moral idea as well. You know, it has a fundamental place in a decent community. And I think there's no substitute for a very disciplined, morally attractive, powerful articulation of it, and a critique of the accounts you think are excessive and the risks that they play by being excessive, and not just excessive as though they're a good thing plus some more good things, but self-defeating to some extent. I mean, I think there's some of the accounts of the rule of law that are in play end up sacrificing the central virtues that you should expect from the rule of law in order simply to maximize effectively opportunities for judicial and legal challenge. They conflate the rule of judges with the rule of law. I think you can say something similar about human rights too. It'd be a bad mistake in my mind to be cynical about the idea of human rights, to pour scorn on them as though they're some kind of mass delusion or deception or plea for power, even if sometimes they're misused in that way. There's a very powerful, sort of morally sound idea that needs to be treasured and recovered and insisted upon. But don't surrender. So don't surrender the terms to people who seem to you to be misusing them, would be my advice.
We'll continue with questions. There are quite a few of them. So the next one is, does parliamentary democracy in practice expand our understanding of who qualifies as a friend, or does it internalize the distinction between friend and enemy?
I'm trying to think what it would mean to internalize the distinction between friend and enemy. I think it joins us, and I don't think I really argued this, maybe it's just presupposed by my argument or alluded to. I mean, any form of decent government is going to join citizens and lawful residents in a kind of peaceful cooperation with one another, a kind of civic friendship, which is valuable and important. And if you don't have that, then good luck establishing public goods and many other various essential things. But you know, a democracy is going to, well, we're not going to achieve that civic friendship by papering over our political differences and disagreements. In some places do, you know, you have a somewhat beneficent king who holds the line by not letting people voice their disagreements. It's not a great state of affairs. And what we do in a parliamentary democracy, I think, and any functioning democracy really, is to allow us to have forceful disagreement on what should be done, where we agree terms under which we'll make decisions, and which one side doesn't think that the other side is cheated such that they don't have a fair shot at decision. And to the extent that political foes start to think of themselves as enemies, then that way, you know, disaster lies. Yeah.
So next question, yeah, there's quite some questions. So could you kindly comment on the idea of political constitutionalism in relation to your account of the political constitution? Thank you.
Okay. So what's political constitutionalism in relation to the political constitution? Well, I suppose I didn't use the term political constitutionalism, of course. I suppose, call myself a political constitutionalist to some extent, although I think I've used the term, clearly I've got to have some appreciation of it. The risk of it, which I hope my talk is partly designed to avoid, is that it downplays the significance of law and the rule of law. So what would political constitutionalism be as a proposition? Well, I think it's a commitment to the value of the political constitution as a way of ordering government, and an attempt to make it more central, or to treasure it, or to maintain it. So to that extent, I suppose I am part of that movement, although whether a legal restriction is an encumbrance on the political constitution or a useful support for it is contingent, I think. I mean, the Parliament Acts 1911 and 1949 are law, and they bolster and supplement and replace to some extent the conventions that otherwise hold between the House of Commons and the House of Lords. And they wouldn't have been necessary except that the House of Lords broke the rules back in 1909 and decided to frustrate the government of the country. At which point you needed some more law to back up the political constitution. But I think, again, it's a project of conservation and management, I think. Although, of course, some places don't yet have a viable political constitution, and they're struggling hard to bring one into being and to maintain it, which is heroic and important work and very hard.
So next question, that's the penultimate question. What accounts for the proclivity of judges to undervalue what you call practical constraints on the abuse of public power? Is it a question of legal education, legal culture, or other trends?
Well, they don't all undervalue it. And plenty of judges across time have seen the significance of the Constitution's reliance on practical constraints, political constraints. But I think it's an increasing unwillingness to rely on them or to credit them with their proper place in explaining the logic and good sense of the arrangements. Now, why is that? Well, I think there's something of a tendency to speculate about horrific hypotheticals. And that, I think, is related to the point I made about a loss of confidence in parliamentarians and in the people. If you think they're always one step away, one banana skin away from genocide or something, then you might think this is just too thin a constraint. Disaster looms around the corner. Thank God we're here. I mean, I think there's a bit of self-flattery in that regard, I'm afraid.
Well, and we will finish with well, there's looks like two questions. So, well, now the penultimate question now. Does Professor Ekins have any thoughts as to why critics are moved to invoke the specter of authoritarians like Carl Schmitt against himself and Professor Finnis for making well-trodden arguments in favor of the political constitution? They could as far more plausibly have invoked the late great Professor Griffith of the London School of Economics, a well-respected scholar of the socialist tradition and political constitutionalist. Why the need for such fevered comparisons?
Well, I presume because it sort of works rhetorically. You want to discredit someone's arguments and banish them from the public square, then that's a much better label than saying, well, you've got an argument in common to John Griffith. And John Griffith was, a lively figure, a talented polemicist who often overdid it, I think. But he's not the figure who gets invoked. I mean, Schmitt is the figure who gets deployed, I think, because it ties in nicely with this this sort of disaster constitutionalist idea that unless the court asserts itself in a novel way, things are going to fall apart. And the idea that they are falling apart and that the people are corrupt and the parliamentarians are likewise or are too weak, that fits in. I mean, I don't mean it's all so cynical, and you'd have to ask David Dysenhouse and others. I'm speculating from what I've read. But I think it tells a story that resonates with what they fear is going on in the world, I think. It's a genuine fear, and that has the advantage of sort of a cheap win, if you like, or apparently cheap win. I'm not intending to put up with it, I should add. I don't think it's a fair argumentative tactic.
And so now we conclude, I guess, the last question. Can you expand more on the 1909 incident with the House of Lords and the political constitution? I thought the issue was essentially decided by the political constitution when the Liberals threatened to make a bunch of Lords. Curious, because we have this issue come up sometime with the Senate, so the Senate in Canada.
Sure. No, I mean, I don't mean that we certainly didn't have to run off to the court to litigate to get them to make up some new law. What I mean is, in 1909, if I'm getting my dates right, the House of Lords refuses to agree to the government's budget that's been approved by the House of Commons. And that is unconstitutional in our funny sense of unconstitutional. It's a violation of the norms of the Constitution. House of Lords should not be playing that role in relation to financial legislation. It should know its place. But it doesn't, it rejects it. And so the government goes to the people, holds an election, partly asking for a majority so we can sort out the House of Lords, determine who's governing the country. And duly returned with a stonking majority, well, maybe, I'm not sure on the numbers, sufficient majority. The government and the House of Commons sets about enacting legislation in order to stop this happening again. So if the House of Lords were to refuse to support financial legislation, or in fact anything else, if enough time's gone by, would be able to force them to comply. But of course, the House of Lords has to agree to that. The House of Commons can't just assert it on its own. And it's true, that's where the threat to appoint hundreds of new members of the House of Lords comes in. So the King, I think rather reluctantly, but agrees that he will act on the Prime Minister's advice to swamp the House of Lords with new peers unless they vote the right way. That's effective. So this is law secured by the political constitution. It's enacted by Parliament, the King and Parliament, secured by the results of an election and the acknowledged primacy and the effective political primacy of the House of Commons. But what you end up with is some law that reinforces the political constitution. So if the House of Lords refuses to let the House of Commons have its way, enough time passes, you get the legislation anyway.
Okay, so we have another question that came up. So, does embracing the political constitution depend on a broad commitment to the political itself and its institutions, so that it is a risk in a climate within which some groups see political gains as being possible only through the courts?
Tell me the question again, sorry.
So, does embracing the political constitution depend on a broad commitment to the political, it's a political in quote, itself as its institutions, so that it is a risk in a climate within which some groups see political gains as being possible only through the courts?
Well, yes, I think it does. If you're committed to the political constitution, you are committed to politics as the mode for settling political questions and deciding how we should be governed, including what law should be enacted. And when groups have a disposition to have recourse to the court rather than fighting things out in the political arena, fighting in the non-violent sense, I stress, then that is a problem. Of course, there are sort of ways, people can do both strategies at once, of course. You can go to the court and you can try and secure advantage or resolution in the parliamentary political process. To my mind, one should discourage the recourse to the courts by, if you can, discouraging it. Yeah, this is not a great tactic in a civilized democracy. You should win fairly in the political process. And if you can make changes to your law and constitution, in accordance with your law and constitution, to make the political more central, then well and good, I think. And I hope behaviour would change in consequence.
Okay, so that's all the questions we received through the Q&A. I don't know if any people would want to ask questions, because you can raise your hand, and if you want to speak and ask your question, you can do it. So, well, I'm looking at the participants. Looks like that's all the questions we had. Yeah. So, well, I guess, thank you very much, Professor Ekins, for having agreed to come here, and I hope the time difference was not too bad for the event. So a little bit of technical issues at the beginning, but that was very promptly overcome. So, thank you for everyone for attending. So we'll be doing more events during the term, so stay tuned, follow us on all the social medias, and in the groups we're going to be posting all our events, and hopefully you'll come back and you're going to like what we will do during this term. So thank you very much, everyone, and see you at next event. It's probably going to be virtual as well, so realities of today.
Thank you very much.
Well, thank you, Professor.